SJC-12256, Commonwealth v. Mark Perkins.
Ms. Nixon, good morning.
Good morning, and may it please the court. Nicole Nixon, Special Assistant District Attorney for Suffolk County, appearing on behalf of the Commonwealth. The search warrant affidavit in this case established probable cause to believe that the defendant was a supplier to the drug trafficking conspiracy being investigated, and that the items sought under the search warrant were evidence of criminal activity and that they would be located in the defendant's residence. The following information supports the inference that the defendant was a supplier to the Hairston Drug Distribution Network, and that's what the issuing justice reasonably inferred in this case in finding that the search warrant established probable cause. First, in a call picked up on a wiretap between Nassim Johnson and Robert Hairston, Nassim Johnson indicates that the source is coming to the deal that occurred on April 23rd, 2014, from Brighton. The defendant in this case lives in Alston. That's where the target residence is located, which is a town immediately adjacent to Brighton. Then on April 23rd, 2015, when police set up surveillance in the area of the Natick Mall, the police see the defendant present in the Macy's parking lot where the drug deal is believed to have taken place. Directly before the drug transaction was directly believed to have taken place, police pick up another call and a wiretap between Robert Hairston and Nassim Johnson. In that call, Nassim Johnson IDs the defendant as his peeps to Hairston. 20 minutes after the drug deal occurred, the defendant is stopped driving the yellow Altima with Johnson in the passenger seat and with the money, which was determined to be approximately $5,200, in the glove compartment. That's significant because in the call picked up between Johnson and Hairston previous to the deal in which they were setting the price, Hairston agreed to pay Johnson $5,200 for the cocaine he had purchased on April 23rd. Then directly before Johnson and the defendant are stopped, the wiretap picks up another call between Hairston and Johnson in which Hairston indicates to Johnson that the cocaine that he had just purchased is wet. Johnson says to Hairston that he has to call Hairston back because he just got pulled over by police. A few minutes later, when Johnson does call Hairston back, Johnson indicates to Hairston that he said to let the cocaine sit for an hour, and he said if the cocaine amount is short, he'll get him on the next one.
If we assume that the affidavit established he was a source of supply, what evidence do you have that any information or any evidence would be contained in his house?
Sure. So if I understand your question correctly.
Let's get past that he was a source of supply.
Absolutely.
All right. How do we get into his house? Or how do you get in his house?
Sure. So the nexus requirement, to meet that nexus requirement, the affidavit needed to show a substantial basis which connected evidence which would be relevant or evidence of the crime, and to show a substantial basis to conclude that that evidence would be found in the defendant's residence. However, to establish that nexus, and especially I think what's important in this particular case, the affidavit didn't need to show or establish a connection between the illegality itself and the defendant's residence. What it needed to show was a connection or a substantial basis for concluding that the items sought under the warrant were first evidence of criminal activity, and second, that they would reasonably be likely to be located in the defendant's residence. And moreover, this connection does not need to be established by direct observation. It can be established by looking at the nature of the crime, the type of evidence sought in this case, as well as reasonable and normal inferences as to where those items are kept.
So what are the inferences that this is sort of a stash house? This is where he keeps his notes, issues like that. What is it about the situation that allows that inference?
Well, I think the distinction here is that in looking at the items that the police were searching for, specifically in this case a piece of clothing, the orange sweatshirt.
The orange sweatshirt's a very good point. Put it aside for a moment.
Absolutely.
All right, just put it aside and tell me where the connection is, that this is his stash house, this is where he keeps his notes. Where do we get that? Well,
I think there's a distinction between a stash house and a defendant's residence. I think what what a stash house is generally held to mean is a place where people or a drug distributor keeps their supply of drugs. And I don't think there's any indication in this case that the defendant's residence was that place. And in fact, police weren't looking for drugs under this warrant. They were looking for items connected to the defendant's criminal activity, specifically records relating to the defendant's drug distribution or drug supplying
I think we're all
activities.
trying to figure out what the connection, we understand the principles that you're supposed to apply. We're trying to understand what is it about this house that established probable cause to believe that papers or whatever it was that they were looking for would be in that place. That's what we're trying to get from you.
Sure.
Other than just this sort of general, if there are records and somebody lives someplace, they must be there.
Sure. So
Is there anything other than that?
well, specifically as to records, there is evidence in this case that all of the players use cell phones to communicate with each other. And I think if you look at the appeals court cases cited to in my brief, Lima and Santiago, they talk about use of cell phones and record generating and the inference that can be drawn by use of cell phones in the sense that it generates records. And here there's evidence that
Records are going to be kept at his home? That's the question. Why is there any nexus between the records, any kind of records, and his house?
Sure. So the nexus, and again, it does not need to be established by any direct observations or direct evidence. And it again doesn't need
But it
to be
doesn't have to be
established.
particularized to this case, to this situation, and not just sort of this general notion that if there are records, they must be kept at somebody's house?
It does need to be particularized to this case, absolutely, and I'm not trying to say anything contrary to that. However, it also can be established by looking at inferences drawn from the information in this search warrant affidavit.
What we want to know is, what is it that connects? Give me one fact that connects this house to papers and records, the items that were sought in the search warrant.
Sure. And again, I think too, inferences drawn from facts is enough to establish a nexus.
Okay.
However, and
Tell us.
sure. So too, the fact that that the defendant himself used a cell phone in this case. We saw the defendant on his cell phone
To do with it.
because the inference is that if all of the players, especially the defendant himself, was using a cell phone to communicate with Nassim Johnson, that there would be bills relating to his cell phone number, which is really what police were trying to figure out in this case, what number the defendant was using to communicate with Nassim Johnson. And the inference is that people keep their cell phone bills, they get their cell phone bills at their residence. And that is a logical inference that can be drawn as to where people generally get cell phone bills, telephone bills.
So the cell phone bill is going to establish what?
The defendant's telephone number in this case. Police were not aware of the defendant's telephone number in this case. However, it would have been of significant evidentiary value because it would have led police to establish a connection between Nassim Johnson and the defendant. It would have shown the number that the defendant was using to communicate with Nassim Johnson to set up these drug transactions and to direct him in terms of setting the price, setting the amount, setting the location.
Was that, and forgive me for this lapse, but was that specifically set forth in the warrant that we're looking for a cell phone number?
It wasn't two contexts. It wasn't a context that police were looking for cell phones themselves,
Right.
which would have indicated contact between the number that Nassim Johnson was using, which police already knew pursuant to the wiretap.
But this information about the cell phone records, that wasn't in the warrant, right?
And the cell phone records would be an example of records relating to the defendant's distribution and intent to distribute cocaine in this case.
And I'm going to ask you now about the orange sweatshirt that
Sure.
Justice Lowy asked you to put aside. Can I ask, on that score, the police stopped him and identified him, right?
Yes.
Are you arguing that the orange sweatshirt would have been identification evidence?
I am, and it would have been identification evidence, and I don't think the fact that the police subsequently identified him in the motor vehicle stop 20 minutes after the deal had presumably occurred negates that evidentiary value. It would have been powerful identification evidence because it would have confirmed the fact that this was the person that police saw
I get it
wearing
if
that.
there's a bank robbery and there's a guy with a polka dot shirt and he's running away and they want to look and they find the polka dot shirt, but how is it probative if they actually stop the guy right after the alleged drug deal, ask for his ID and find out you're Mr. Perkins, okay, and then they send him on his way? How is that relevant?
It's probative to confirm the fact that the same person who was driving the vehicle was the person present at the deal who Nassim Johnson identified as his person in the Macy's parking lot.
But they found him in the car wearing the orange sweatshirt, right?
I believe the information in the affidavit doesn't establish if the person who they identified as Mark Perkins was specifically wearing the orange hooded sweatshirt in the car. I think it's presumed that that was the case.
I would assume.
But it wasn't specifically identified in the affidavit.
So he was wearing the orange sweatshirt in the parking lot?
Yes.
But we do not know whether or not he was wearing the orange sweatshirt in the car.
Well, I think it can be inferred or presumed, however, it's not.
If he was wearing the orange sweatshirt in the car, is there any meaningful justification for a search? You know, I would understand it if there could be serious questions about the ID, but if he was wearing it in the car and he was stopped by the police officer, do we have a meaningful ID issue which would be justifying the invasion of somebody's home if that were the only basis for it?
Well, I think too, we need to go back to the standard for probable cause, and that is whether the item that you're searching for is evidence of criminal activity or of evidence of the defendant's criminal activities. And in this case, it would have been evidence of identification. It would have placed him and confirmed the police's surveillance and the police's observation of this person who Johnson identified as his peeps or his person in the Macy's parking lot at that point in time. I don't think the fact that they stopped him they stopped a car 20 minutes after the fact, the defendant was identified driving that car, negates the evidentiary value of the police finding an orange hooded sweatshirt that they observed on the date in question to connect the defendant to the drug trafficking conspiracy and to show that he was the person that police saw on that day in question.
They got his driver's license, though, right? When they looked at him, they stopped him and said, "You are Mr. Perkins."
They stopped him and identified him. That's correct.
Do you know whether he's wearing an orange sweatshirt in the booking photo? And the reason I'm asking, it's sort of obvious, is it's one thing to have testimony that he was wearing an orange sweatshirt, and it's another thing to show the jury and walk along the jury with the orange sweatshirt. But if he's in the booking photo with the orange sweatshirt, it's not really that important. And I assume that the booking photo was before the warrant.
The booking photo itself, it's not talked about in the warrant. It wasn't attached to the warrant as an addendum.
Because if he's wearing the orange sweatshirt in the booking photo, it sort of eviscerates, I think, the best argument, which is it's one thing to talk about an orange sweatshirt, but it's better to show the jury the orange sweatshirt.
Yes. The booking photo wasn't part of the four corners of the search warrant affidavit. It wasn't part of the record before the issuing justice. I think that the issuing justice in this case was confined to review the four corners of the search warrant affidavit, and the booking photo or a booking photo wasn't part of that.
If putting aside the orange sweatshirt again for a moment, we'll get back to it. If you are right, is there any meaningful nexus requirement anymore with regard to a drug dealer? Or can we infer that once we determine that once there's probable cause to believe the person has been involved in dealing drugs, then, based on the inferences in your affidavit, you can always search the home for some records?
I think that there still is a meaningful distinction because there still needs to be factors met that were apparent in this case. First, that this wasn't just a street level dealer or a dealer dealing drugs to support his habit. This was a supplier. It could be inferred from the facts in the affidavit, at least, that this was a person who supplies drugs to a drug distribution network. Not only supplies a small amount of drugs, but it can be inferred from the facts in the affidavit that he deals in large amounts of drugs and he reaps large amounts of profits. I think that's an important distinction in this case.
Why would that mean large amounts of records? I don't understand.
Because the inference that can be drawn from the fact that this was a large-scale operation is that this is a business enterprise to record the business enterprise and record his business dealings. I don't think that you can make the same inference.
Records are kept, but where are they? That's the missing link here.
And if you look to United States v. Felice, which I acknowledge is a First Circuit case, however, if you look to that case, they talked about the logical and common sense inferences you can draw as to where these types of things would be kept. And I think that the nexus requirement does not need to be established by direct observation. It can be established by looking at logical inferences as to where items would be kept. And I think that's the distinction in this case. I see that my time has come to a close, so
One more question. If the search was based solely on the orange sweatshirt, would it survive?
yes, it would survive because the question before the issuing justice in this case is to look for whether there was probable cause as to any of the items sought under the search warrant, and the orange hooded sweatshirt in this case was sought by the affiants. So yes.
All right, thank you.
Thank you.
Mr. Hennessy, good morning.
Good morning, Mr. Chief Justice. Robert Hennessy, and at council table with me is Attorney John Thompson, and we represent the appellee Mark Perkins. I think it would be worthwhile to review just briefly a few of the uncontested facts in this case. First, it is uncontested that the affidavit underlying the search warrant does not describe a single transaction or any other illegality being observed, suspected, or reported to have occurred at or near 1399 Commonwealth Avenue. Additionally, neither Mr. Perkins nor any target of the ongoing investigation was ever observed traveling to or from the target residence either before or after any alleged transaction. Third, in the nearly 500 pages of wiretap transcripts contained in the application for search warrant, Mr. Perkins is not a party to a single intercepted conversation. And finally, the voluminous transcripts of those conversations do not contain a single reference to the defendant by name, his telephone number, or the residence at 1399 Commonwealth Avenue. I would suggest that on these undisputed facts, there was absolutely no error in the motion judge granting the motion to suppress in this case.
Because there was no probable cause to believe he was engaged in drug dealing, or because of nexus?
I would say that there was no error in both findings.
I don't remember the judge finding that there was no probable cause to believe he was engaged in drug dealing.
Well, what the written findings of the motion judge were that there was no information to establish whether he was involved in this overall conspiracy, and there was absolutely no information to establish what role, if any, he played in this conspiracy.
Why would that matter? Let's assume he was not part of this conspiracy. He was just an independent operator who happened to make a single drug deal as described at the Natick Mall. Would that not indicate that he was involved in the supplying of drugs, at least for that particular transaction, which was only 7 days before the search?
It was 7 days before the search. I would submit that in terms of the inferences that Mr. Perkins' position on this point is that the inferences that the Commonwealth are drawing to establish this connection or this participation in this particular transaction are far too attenuated to establish probable cause. But that's putting that aside, point A. Point B is there is absolutely no nexus established between any illegality and the target residence in this case.
Well, let's take the Commonwealth's best argument and put aside A, because you're lucky you're not here only on A with probable cause. It seems pretty clear there's probable cause in the four corners of the affidavit. So take their best argument that this is a layered drug dealer. He's not a street-level drug dealer. He's some sort of a boss. And that we have evidence that's going to be corroborative, and jurors love corroboration. It's their favorite thing, of an orange sweatshirt in the apartment as well. So that's their best argument. You put those two things together. Does that get you to nexus?
Well, as a preliminary matter, I would say that their best argument, if that's what indeed it is, was waived by not raising it before the motion judge. It was never raised at the motion judge. It was never raised in the opposition to the motion to suppress. It was not raised in the motion for reconsideration. No questions at the evidentiary hearing that was held pertained to the issue of the orange sweatshirt. And then even in their brief that they filed in the appeals court, the orange sweatshirt does not apply in the statement of the issue to be raised in court. My argument would be that under Betancourt, that issue is waived and cannot be used to reverse the the motion judge's ruling.
But assume it's not waived.
Okay? Assuming that it's not waived, I think I see two problems with the issue. The first is that in order for mere evidence of a crime to be this object of a search warrant, it has to have the potential to either aid in the apprehension or the conviction of a particular defendant. I would say in the context of this case, where there's been a positive identification made, it doesn't have the potential to do either of those things.
Is that a legal standard? That the government's evidence is good enough, they don't get to have extra evidence?
No, certainly that's...
Because would you admit that the orange sweatshirt, if they came to trial and they trotted out the orange sweatshirt, it'd be admissible, right?
It would be admissible to show that the person that they observed in the parking lot wearing an orange sweatshirt is the same person as the defendant?
In other
it's relevant.
words, ID in the face of the ID instruction as we have it now. It's pretty powerful corroboration. You got an ID identification that's going to be given, and you've got recipient witnesses talking about orange sweatshirts, and then the DA walks it along in front of the jury.
Well, I think there's a couple issues with the strength and the power of that as identification evidence. The first is that this notion that it is a distinctive orange sweatshirt, it is never alleged in the search warrant affidavit itself. It's sort of
when is strength and power part of the probable cause inquiry?
I'm sorry?
It goes back to my original question. Is there your evidence is good enough exception to the warrant requirement? When is strength and power relevant to us? Isn't it whether or not there's just probable cause and this is evidence of a crime?
Well, there's also...
It has to be really good evidence of a crime?
Well, there's... the point in the context of the probable cause determination that I'm trying to get to is that it's the question of whether or not it is described with particularity. The way it is described in the search warrant application and the search warrant that issues is an orange sweatshirt observed on April 24th. The distinctiveness of this orange sweatshirt is not established either in the affidavit or the application for search warrant. There's no suggestion that it's a zippered orange sweatshirt or not zippered orange sweatshirt. What shade of orange is it? Whether or not it has writing on it. Is it distinctive writing?
Well, if we were in Syracuse or Denver, that may be more persuasive, but we're not. So orange is a bit more distinctive here than it would be in those cities where they have sports teams, which orange is their color. I mean, it's not that usual a color. It's not a dark. You know, if it was, I understand if you were to say dark blue sweatshirt, it may not be distinctive enough to even be evidence, but orange is a bit unusual.
Well, that still leaves the other question is, you know, what is the, taken to its logical conclusion, what is the effect of this sort of basis to justify an otherwise unlawful warrant? Say, you know, the case law in Massachusetts is clear that probable cause to establish that there's involvement in any sort of criminal activity does not give rise to probable cause, a nexus to search a defendant's home. In this case, what in essence would be occurring would be there would be
You're doing fine, Mr. Hennessy.
Thank you very much. There's an observation of someone allegedly involved in illegal activity. So in the absence of any information connecting that activity to the resident's home, you can just say, well, he was wearing a red shirt at the time that I observed this. In the vicinity of an alleged transaction, not in the alleged transaction. I think there's been some misrepresentations with regard to the strength of the evidence of his involvement in that parking lot. But, so if you just throw in the idea that he was wearing a red shirt or an orange shirt or a purple shirt or a polka dotted shirt at the end of your search warrant affidavit.
So the police could just lie about the fact that he has a type of distinctive article of clothing?
Well, I suppose it begs
that
the
your
question,
argument?
at what point does the article of clothing become distinctive?
And the
I
police,
mean, as
and the
Chief
police
Justice-
could just lie and say, we saw him driving out of the house with drugs in his pocket. I mean, holding drugs. So are you saying we should invalidate this because the police could use this to lie? Is that your position?
No, what my position is that the reason that probable cause to believe a crime is committed does not give rise to probable cause to enter a home to search for evidence of that crime necessarily without some nexus is because of the special protections afforded to the home in the context of both the Fourth Amendment and Article 14. What I'm suggesting is that an article of clothing that has no independent significance, like in a murder case where an article of clothing is suspected to contain blood evidence, or in a shooting case where an article of clothing is suspected to contain gunshot residue, some additional evidentiary significance beyond the fact that someone was observed wearing an item of clothing, and then we can presume that people keep their clothes at their home, so that's going to get us in. Notwithstanding, I'm not suggesting that there's a lie about the color or the type of clothing, but what I'm saying is it's essentially an end run around the protections that this court has consistently put forward with regard to searches of homes.
Well, this
in
raises
drug
a
cases.
somewhat different issue. I mean, I'm not persuaded if you have a bank robbery and the person is seen to be fleeing in an orange sweatshirt and you have probable cause and that you could not go to that person's home and see whether that person indeed has an unusual orange sweatshirt, because that would indicate that perhaps the person fleeing is him. The issue in this case, which I've never seen before, frankly, is there is an argument that says there's not really an ID issue here, that the orange sweatshirt here is essentially adding, what's the term, to something that's already established. That
Corroboration.
Sorry?
It's corroboration.
Well, arguably, but corroboration ID may not arguably be an issue, because if they indeed did see him in the car, then there's no real dispute that he was in the car, and so the orange sweatshirt does not become a meaningful ID issue. But then that goes to Justice Gaziano's question of how strong must it be to justify the search of a home? I've never seen the issue before. Are there cases which have addressed the question of whether there must truly be an issue in dispute for it to be evidence?
In my research in looking into cases involving search warrants to search for items of clothing, what I've come across, and one example is this court's case in Commonwealth versus Cavett, which is 460 Mass 617, are searches for, as I suggested, trace evidence of the crime. In Cavett, there was an issue involving blood, tissue, or fragments of clothing that may have transferred between the men during a fight that would be relevant to the identification of the defendant as the perpetrator of the armed robbery. It wasn't just the item of clothing and some assessment of how common or uncommon that is, generally speaking, within the population in which you're looking at. It's specific, particularized, articulated evidence of the crime at issue was what, I'm sorry.
Well, let's just go back to Chief Justice Gantz's question for a minute. And I guess the issue is assuming, without deciding, that the orange sweatshirt is cumulative of other issues that would establish identification. If it's distinctive enough, I'm not saying an orange sweatshirt is, but say somebody's wearing, I don't know, a Seattle Pilots, the predecessors to the Milwaukee Brewers, and Houston Oilers, who are no longer the Houston Oilers. They're wearing that outfit. I mean, that's just crazy. If you, distinctive, you're not saying they couldn't go in to see if that's in their house? If it's a pure ID case and it's not cumulative?
If it's a pure ID case and what's at issue, is simply the ID. There's no other ID evidence. This is the only evidence to establish. It's almost like to establish the ID of a telephone.
I mean, what's the chances of somebody having those two things, wearing those two things? So you've got incredible distinctiveness. It's not cumulative. So that would be enough, wouldn't it?
Well, that would certainly give it more evidentiary value than the orange sweatshirt in
Well,
this
that goes
case.
back to Justice Graziano's point. Where do we have something in our case law that says that if something's just going to add to the weight, it's not enough for the police to search for it, if it's got evidentiary value?
I don't believe that, I'm not conceding that,
I know you're not.
yeah, that if it were a Brewers sweatshirt or, you know, or whatever, Hartford Whalers sweatshirt, which are no longer in vogue, that would make that item of clothing more distinctive objectively. You know, just there are probably fewer Hartford Whalers jerseys left than there are hooded sweatshirts of any particular color, which are probably the most ubiquitous item of clothing in modern America. But I think that the problem that I'm talking about, well, let me just take one step back while I still have time. I would suggest that in this case, where there is assertedly a positive ID of this individual who was seen, and that positive identification of that individual is sworn to under oath and used as a crux to even get to 1399 Commonwealth Avenue. I mean, this notion that we're going to use this, you know, arguably pretextual stop to get the identification of the people in the car, use that to use RMV records to get to the address, but then we're going to say, well, you know, that's not enough. Now that everything else in our case has fallen apart, we're going to say, well, we saw this orange sweatshirt. I think that is an impermissible end run around the protections.
Suppose the orange sweatshirt was the sole basis for the search warrant. I mean, that's really what they wanted to look for. Does that make a difference?
I would submit that the search warrant, if this was limited to the information actually involving this defendant in this home, I suggest that the search warrant never would have issued on this case. What we have is a whole bunch of small issues buried in here, and I don't think that the search warrant would have issued if it was based solely on an orange sweatshirt, because there's no real connection between the illegality, the sweatshirt, and the place to be searched.
Before you leave, one last question. If you do not prevail on the orange sweatshirt question, and if we were to find that that would be sufficient to justify the search, was the discovery of the key of cocaine in plain view?
Well, that's an issue that, you know, and this is one of the reasons why I suggest the orange sweatshirt argument is waived. That's an issue that was never briefed or argued below. I think when you shift into a totally separate legal argument like this orange sweatshirt and harmless error because of things being found in plain view, you know, it raises issues about the scope and the intensity of what type of search would have been justified for this hypothetical orange sweatshirt. I think that there would have to be an evidentiary hearing to make those determinations because the judge was never asked to make them in the first instance.
Okay, thank you.
Thank you.